Welcome everyone here today, and welcome to those that we're videoing in at home. I come at an interesting time because you may have heard this morning the Prime Minister's announcement about a travel for ban anywhere overseas, as well as the gathering number of 500 being moved down to 100 and being outlawed and therefore subject to various exceptions, for example, schools and the like. So we live in interesting times. My wife and I are organising a wedding for 98 people. So I'm not sure if that, we have to review that. We don't have to sack anyone at the moment, but I think we'll be postponing our son's wedding, which is set for the 18th of April. Again, just how these events affect your life. Good to see some familiar faces around the room. And this is the ethics session, ethical issues in internal external communications for in-house counsel. And if you travel with me today's journey, you qualify for your mandatory 1 point. So welcome to the journey. Apologise up front that a lot of the issues that we'll discuss today are quite obvious. However, we've got an annual renewal obligation of our ethics obligation, which our masters rightly believe needs continual reinforcement. So bear with us as we go through this journey. Overview. In terms of the role of in-house counsel, as the landscape of the legal profession changes, more and more lawyers are moving in-house. The Australian legal market sees both corporate and government clients consistently seeking more for their money from their external solicitors, like us, and increasing the workloads of their own in-house solicitors. In-house counsel are commonly involved in all aspects of a business, particularly when issues arise. What are the ethical obligations when in-house counsel is so involved, including having to deal with internal stakeholders, board members and senior executives, and including dealings with regulators? And when external parties become involved, what ethical issues can arise in the ongoing process from engaging and dealing with external advisors, other parties and their lawyers, and the regulators? This includes during compulsory examinations conducted by, for example, ASIC and by the ACCC. The role of in-house lawyers and general counsel is much the same as lawyers in law firm. You, like us, are legal representatives who have duties to both the court and to the client. But your client is the organisation and also your employer. Your role is therefore a balancing act because your role is not just as a lawyer. We will address these issues later in the presentation. As an in-house lawyer, you may feel that you are intertwined in the business. The challenge is when tensions arise between your legal obligations to the court and your client versus management/business demands versus your position as an employee. One American legal commentator puts the demands as follows: the in-house lawyer's deep involvement in the day-to-day business can lead to a high level of accountability in ways not affecting lawyers in private practice. For example, in-house lawyers are now more frequently in the crosshairs of regulators and are expected to be the gatekeepers whose job it is, in part, to keep the company honest. So to what extent should you get involved as a lawyer? We'll talk about that further in the context of legal professional privilege and in the context of the risk of an in-house lawyer becoming a material witness. We're dealing with internal and external dealings. Internal dealings, your involvements in disputes and investigations, and external dealings, your interactions with external counsel, regulators, and other parties to dispute and their legal representatives. Internal dealings and communications, the typical steps in a dispute or issue process are identified in the slide in front of you. Business identifies and seeks to resolve an issue, possible involvement or contact from a regulator, referral to a legal team, advice to stakeholders, working with the business to resolve the issue, and liaising with the regulator as to appropriate steps. There are many benefits to an in-house legal team and to working as an in-house lawyer. These include the involvement and deep knowledge of the business, its mission and its stakeholders. It can potentially bring a very tailored and commercial approach to advice. Your early involvement in an issue can assist with effective strategising. The benefits include exposure to the entire business and the other considerations at play. It is not a purely legal role. This includes exposure to the decision makers and may lead to other diverse roles and experiences. Also, luckily, no billables, no timesheets for you. But for the client, the risk associated with in-house lawyers are the potential for members of the legal team to become witnesses and also the associated issue of loss of legal professional privilege. For the in-house lawyers themselves, the difficulties that they face include their involvement in the business blurring the lines of their legal role. Unique ethical problems can arise which impact both the client and also the lawyer individually. Two issues that relate to internal dealings and communications are firstly, the potential for an in-house legal team member to become a witness, and second, protecting a privilege in the context of internal investigations. Obviously, the greater the involvement in investigation and decision-making process, the greater the potential to be involved in the decision outcome and therefore target investigations. Compare the in-house position to that of external counsel. If external counsel providing specific advice, the lawyer is unlikely to be anything more than an advisor. However, when detailed involvement arises, the lines can be blurred. We suggest keeping in mind the restrictions on being a witness and also being involved in the conduct of the matter. We'll look at shortly at the Australian Solicitor Conduct Rules issues with that. At an early stage, particularly in-house, do think about how far you can go to maintain the ethical position as lawyer and avoid becoming embroiled as a witness or relevant person. Privilege is a major consideration for all legal work. In relation to investigations and disputes, the courts take what we think is a more restrictive view on the existence of privilege when in-house lawyers are conducting cases overseeing them. I've set out in this slide Rule 27 of the Australian Solicitors Conduct Rules. In February 2018, the Law Council Australia published a circular called The Review of Australian Solicitors Conduct Rules. The report says, quote, Rule 27.1 implies that it is discretionary for a solicitor to determine whether to appear as an advocate for the client in the hearing in the circumstances outlined in that rule. It is recommended, says the Law Council, that the word may not be amended to must not. Legal professional privilege. Now, the scope of privilege is wide. It obviously goes much further than advice in litigation and extends to work in anticipation of a dispute or for proper legal advice. The courts accept that corporations subject to complex regulations will need to consult their lawyers openly in order to comply with their legal obligations. Privilege is increasingly referred to as client legal privilege in statutes, as the privilege is indeed the client's. Remember, it is the client which is the one who can maintain or waive or lose privilege. Note, to the extent that corporate privilege is said to promote greater compliance by encouraging corporations fully to investigate suspected legal breaches of the law and rectify them, this is already a standard of conduct that can be expected of directors as part of their duties of diligence and due care under the Corporations Act. Privilege is available where the lawyer's advice is independent. We'll return to that shortly. If one party has an improper purpose in seeking advice, then it will not apply. That is very rare and unlikely to arise in these circumstances. Protecting privilege. The prior sole purpose test has been subsumed following the well-known case in Ground and Downs to the dominant purpose test. When the court is looking at the purpose behind a corporation conducting an investigation, and specifically whether the investigation was for the dominant purpose of legal advice, different considerations apply to those conducted by in-house legal counsel. The corporation's specific intentions will be examined, and as the cases will show, even when those involved give evidence as to their reasons or intentions, that can sometimes be insufficient, as the court will examine objectively what the intent was. I refer there to the case of Singapore Airlines and Sydney Airports Corporation, which is a judgment of Bob McDougall, and that involved this case. In February 2001, an aero bridge operated by Qantas hit the door of a Singapore Airlines plane. In-house counsel for the corporation, Sydney Airports Corporation, was informed. She formed the view that litigation was likely, and then commissioned an expert's report in contemplation of litigation and anticipated legal liability on the corporation's behalf. It also said in the commissioning of the report, its contents are to be kept strictly confidential and its circulation is to be limited. That day, Singapore Airlines served a notice on the Sydney Airport Corporation seeking reimbursement for damage. The corporation claimed that the report commissioned by the in-house legal counsel was subject to legal professional privilege in application of the dominant purpose test. It was held by McDougall J, upheld on appeal. The report was not privileged. That's because His Honour found the report had a number of purposes, which I'll come to now. The judge identified 4 purposes that came out of the evidence in the case, and just to read them out to you. He said it's possible to assign at least 4 purposes or intended uses of this report. Firstly, for use in litigation that the in-house legal counsel thought was likely, including in this to qualify a witness as an expert who could give evidence in the litigation. Second purpose, to enable the corporation to understand what caused the incident. Third purpose, to enable the corporation to allay the concerns of the Airport Operating Committee, both in relation to the particular aero bridge and in relation to other similar aero bridges, so as to persuade the airlines, the AOC, to allow the aero bridge to be put back into service. And fourth of 4, for the corporation's own operational reasons, to seek to ensure that similar incidents would not occur again. So he found a number of purposes, and he felt the objective circumstances relative to the corporation was that it was not the dominant purpose. It had other mixed purposes, notwithstanding the view of the in-house counsel. So the corporation was unable to show the purpose of the use in litigation was the dominant purpose. In terms of protecting privilege, independence is important. A senior in-house lawyer is usually part of the executive team, so therefore may not be entirely independent. You also need to consider subsidiaries and related entities of the employer corporation that you're contracted with. You should also consider the process of preparing advices, the role of the internal stakeholders in contribution to that advice, and who the advice was given to and reviewed by. Next slide, I put up the case of Archer Capital, which was determined by Justice Wigney. And the judge posed for himself the question of whether, as well as satisfying the dominant purpose test, it must also be established that the communication in this case was sent or received by the solicitor in his capacity as an independent legal advisor underlined. So that was the challenge, as to whether this additional requirement was required in the mind of the judge. It was held by the judge. Whether the privilege arises is a question of fact. The advice is to have an independent character which flows from the nature of the professional relationship between the relevant legal advisor and their employer. For a privilege to attach to the communications, it must be provided by the legal advisor who is consulted in a professional capacity in relation to a professional matter and the communications are made in confidence and arise from the relationship of lawyer and client. The judge doubted there was any reason in principle why to attract privilege in these circumstances it would be necessary to also satisfy some element of independence on the part of the employed solicitor. For example, by proving the lawyer was not subject to pressure or interference arising from the employment relationship. He says, I doubt there is a separate or distinct requirement to prove independence. Any requirement of independence on the part of the in-house lawyer is an aspect of the relationship between lawyer and the employer-client and the capacity in which the lawyer is consulted. Moving to external dealings and communications, the in-house lawyers will often deal with external parties in conducting their day-to-day business. These parties include external law firms, barristers, former employees or expert who might be engaged for advice or as part of a proceeding. When dealing with external parties, in-house lawyers' roles can essentially change from lawyers to project managers and or instructors. The role of in-house lawyers in these contexts is also to facilitate access from the external party to the appropriate division within the organisation so that they can take instructions and conduct proper assessments. In-house lawyers act as key source of information for external parties in these contexts, as they are able to provide valuable knowledge of the business, its policies, its missions and its stakeholders. When dealing with these kinds of external parties, in-house lawyers should be prudent in ensuring, as best as may be possible, that the people they are briefing are themselves not conflicted. Whilst it is incumbent on external lawyers and law firms to do this themselves, in-house lawyers should still be conscious of this, particularly when briefing counsel or experts. Such conflicts could involve the external parties previously acting or working for stakeholders of the business, or their shareholders, or their former employees, etc. In-house lawyers should consider engaging external lawyers for high-risk matters. A senior legal advisor can also be considered a decision-maker of a business. Consequently, a large amount of what an in-house lawyer does is potentially discoverable. Further, external lawyers are often in a better position to give frank and fearless advice, as they do not run the risk of any potential fallout from the day-to-day relationships and culture of the business that the in-house counsel works within. When a private firm is dealing with in-house lawyers, they should utilise them for their knowledge of the business, their commercial mindset and their knowledge of the policies and procedures that exist in the organisation. In doing so, private firms will be better equipped in undertaking their work for and on behalf of the client. I set out next slide some obligations and sources of those obligations. The uniform rules, the first top point there, have been adopted in South Australia, in Queensland, Victoria, New South Wales and the ACT. And they bring into bearing the solicitor's conduct rules. We talk about Rule 11 shortly in the context of dealing with conflicts of interest. Civil Procedure Act. There is one section there which I was going to deal with, which is Section 56 of the Civil Procedure Act, and that deals with the overriding purpose of the Act is to facilitate the just, quick and cheap resolution of the real issues in proceedings. That's the overriding purpose. A party to civil proceedings is under that duty of overriding purpose, and each of the following persons, any solicitor or barrister representing the party to the proceedings, which you'd expect, but also any person with a, quote, relevant interest in the proceedings commenced by the party. Now, a relevant interest means any person who provides financial assistance to any party in the proceedings, but also includes any person who exercises any direct or indirect control or any influence over the conduct of proceedings or the conduct of a party in respect of the proceedings. This would relevantly apply in most instances to in-house counsel as the instructor. So that's an obligation that they have independently of the lawyers they instruct and the barristers they instruct. I refer to the model litigant policy for civil litigation. So this is a for New South Wales government lawyers, and it applies to civil claims and civil litigation involving the state or any of its agencies. It requires the state and its agencies to act with complete propriety, fairly, in accordance with the highest professional standards. It goes probably beyond what we're bound by as lawyers on the record, in the context that a model litigant cannot take advantage of a claimant who lacks resources to litigate a legitimate claim. Quite often sometimes we will have cases where the party with the deepest pockets tends to be the one that prevails in lengthy litigation. That's an obligation that we don't have, but it's an obligation that in-house government counsel would have. In-house counsel, government-wise, can't rely on any technical defences, and it also extends to apologising where the state or an agency is aware that it has acted wrongfully or improperly. It goes on to say it doesn't prevent the state from acting firmly and properly protect its interests. It can still rely on claims of legal professional privilege. It can still rely on seeking security for costs from a plaintiff, and also can move to strike out or otherwise oppose untenable claims which are an abusive process. So there's some exceptions there, but state government lawyers, model litigant policy for civil litigation, and you can take a copy of that if you need to after the talk. There's also a publication by the Law Society of New South Wales, a guide to ethical issues for government lawyers, 3rd edition 2015, and it covers, amongst other things, model litigant, as well as confidentiality and giving policy advices alike. But I've found that quite a comprehensive review of the particular ethical issues that apply to government lawyers. So again, I commend that to you if you're a government lawyer. Moving on to obligations, independence and avoiding conflicts of interest. Acting in your client's best interest. First question often is, who is your client? It's the organisation, and it's not an individual member of the management. It's not an individual employee. Your client may be hard to identify sometimes because an employee can be an extension of the organisation, for example, your instructor. But remember that your role is to endeavour to act in the best interests of the organisation and not individuals within it. This can be difficult because your colleagues may see you as their lawyer, so you therefore need to make it clear you represent the organisation. And where appropriate, remind your colleague that he or she has the right to obtain their own counsel or representation. So recognise situations where an external lawyer may be needed. Internal investigations, probably appropriate for the employee concerned to seek their own independent legal advice, and make it clear that you act for the organisation and they have the right to their own legal representation. In terms of external investigations, you may be conflicted out of being able to act if you're involved in giving advice in relation to the matters the subject of the investigation. For example, you're a witness. You wear multiple hats, and again, just the balancing act process that you go through as an in-house counsel. You're providing legal advice. You're often involved in the day-to-day running of the business. You may be involved in the business and strategic decisions. You're increasingly having to have interactions with and dealings with the regulators, as I indicated previously. There's a risk of having these model aspects in your role. You might find yourselves being asked to essentially act as a lawyer and business partner or advisor. The risk in acting as a business partner and being involved in the decision-making side of the business is those communications that you're involved with are unlikely to be legally privileged. So tips, how can you manage the different roles you have as an in-house lawyer? Consider the purpose of the task at hand. Are you providing legal advice, for example? Set out the legal purpose of your communication at the beginning of the email or document. In the case of legal advice, you need to either set out the legal purpose of your communication up front or mark your advice as privileged. I think separate your business advice from any legal advice, ideally through separate documents or clearly divided by subheading. Properly mark privileged communications. In the perfect world, educate your non-lawyer colleagues, management and the board about the difference between legal and business advice and how and when legal privilege applies. I do say in the perfect world. The types of conflicts in the in-house setting. So consider your own conflicts. For example, prior advice to the organisation, how your current actions or ability to be impartial may be impacted. Conflict that may arise from your previous experience as a lawyer in private practice. There's also the conflicts at the management executive level or board level or at the employee level, as I've discussed previously. Independence, the avoidance of personal bias. The lawyer's paramount duty is to the court. That's under Rule 3 of the Solicitor's Rules. A solicitor's duty to the court and the administration of justice is paramount and prevails to the extent of any inconsistency with any other duty. So that's the paramount rule. Acting as a solicitor always requires an element of independence, and you cannot just act for the company/client without taking this paramount duty into consideration, the paramount duty of the duty to the court. Obligations of independence. The rules require us to advise honestly, competently, diligently and be independent. That's under Rule 4 of the Solicitor's Rules, called Other Fundamental Ethical Duties. Legal advice should be provided even if the organisation dislikes or is displeased with it. Unfortunately, our role isn't one which enables us to always tell clients what they want to hear. And like all clients, it is a matter for the organisation as to whether or not it is the advice provided is accepted or rejected. Independence, what can we do? Okay, a number of things we can do. Your instructions. So question what you're being asked to do. This is often easier said than done because you're an employee too. In terms of pressure, develop strategies to deal with it, what is sometimes referred to as the management squeeze or pressure from up the ladder. Be careful to resist the pressure you may experience. As I said before, for example, to provide advice that your organisation wants to hear. Don't be tempted to advise that the desired position is arguable if you don't consider that to be the honest case. It's easier said than done, as I said, and you're an employee too. There's a default mechanism, which of course is to seek assistance of external lawyers, including counsel, if that's appropriate. Escalate. So to escalate and recruit support, and the key is knowing when to escalate. For example, pursuing claims or defences without merit. So an example might be you commenced a proceeding without a proper basis. You're advised by lawyers, external lawyers, the proceeding should be withdrawn. That's refused. Don't stop there, you should escalate to the appropriate person, either within the organisation or external lawyers, including counsel. The next slide is a case study. And I'll just read through the elements there. Joanne is a manager who commenced a proceeding without seeking the advice of Company A's in-house legal team. Upon becoming aware of the proceeding, the in-house lawyers sought the input of external solicitors and counsel. The external solicitors and counsel considered that the proceeding should be withdrawn. There was no proper basis. The in-house lawyers agreed. Joanne refused to follow the advice to withdraw. She said it was the only option left. The in-house lawyers called Joanne to persuade her to follow the advice. Joanne wouldn't heed the advice. She wanted to press on. Joanne instructed the external lawyers to prepare for the hearing. The external lawyers continued to make the efforts to persuade Joanne to withdraw the proceeding. The day before the hearing, Joanne decided it would be best to withdraw. So the question I pose there, what would you have done differently in your role as an in-house lawyer? Could I just open it up to those in the crowd as to what you may have done in that situation? There's one clue there, which is, I suppose, Joanne is a manager. So one element of this case study is the ability to escalate from the lawyer's point of view to hire someone higher above Joanne in that situation. That's obviously one obvious answer. And it has obviously difficulties from the instructing lawyers as well, because we obviously got the duties to the court I explained before under Rule 56, but there's also rules available to the judge to order costs against the solicitors personally for unmeritorious claims, etc., etc. But in this case study, in this situation, you'd expect a letter from the lawyers who would say or confirm their advice and recommendations to protect their position. Nevertheless, they still got the personal possible liability of a cost order against them with an unmeritorious claim. Now, moving to our final slide, conflicts of interest. Under the rules 10, 11 and 12, a solicitor in a law practice must avoid conflicts between the duties owed to current and former clients, concurrent clients, and also to avoid conflicts between their own interests and their duty to best serve the interests of a client. A conflict arises where these duties or interests conflict with one another. It very commonly arises in relation to confidentiality, when you have confidential information about a client which you could use to serve the interest of another client or yourself. When that situation arises, particularly as between two clients, you find yourself required to breach your duty to one of your clients, i.e. you either breach confidentiality and disclose information to the other client, or you breach your duty to protect the interests of your client by withholding information that would assist their case. Because the conflict results in a breach of duty, you simply cannot be in conflict, and if you find out you are, you have to take steps to extricate yourself. All lawyers need to take care to avoid conflicts of interest and address them if they arise. But in-house lawyers are in a unique situation which may put them squarely in conflict. For in-house lawyers, generally, you'll only have one client, so there will not be the concurrent client conflict. However, you may find yourself in conflict as a result of your previous work in private practice, or perhaps in conflict due to your own interests. Or potentially, there may be a conflict between your duty to your client and the interests of other stakeholders within your client. For example, you may become aware that another employee has a claim of some sort against your organisation. The problem with ethical dilemmas is they are each unique, so it's difficult to provide general advice on what to do. But as a general rule, it is best to act early to avoid a conflict wherever possible. In many instances, it may be that you are unable to continue to work on the matter when you are so conflicted. So to finish up, before any other questions or comments, I'll put you, just make a note of this. The Law Society of New South Wales has a ethics assistance line. I've used it from time to time. It's 99260114. It's on the website. Or ethics@lawsociety.com.au. And they've usually got officers there available to speak to Monday to Friday, 9 to 5 at 170 Phillip Street. I've used them over the years in relation to commercial conflicts. So often you've got a potential set of instructions coming in, and I will ring them on a hypothetical basis and set up the situation. And sometimes this reinforces your decision of whether you can act or you can't act as well. And I'll probably use it once every 2 years on average. But it's there for lawyers to use. They're very helpful. They keep it confidential, and they also, as I said, are very available. So that's a bit of a advertisement to the ethics assistance line of the Law Society. All right, that concludes the talk. Any questions or comments going forward? People listening at home can't say anything, but any people there? Otherwise, if not, I congratulate you on achieving your one ethics point for this year. Well done.